When his father died, he inherited the farm. What he didn't know was that he had also inherited an open mechanics lien, an active boundary dispute still pending in circuit court, and a co-owner his father had never mentioned to anyone in the family. All of it was waiting in the courthouse record the day the estate closed. Inheritance transfers a deed. It does not transfer a clean title. Every encumbrance, every open dispute, every recorded instrument filed against a parcel during the prior owner's lifetime comes with the land whether the heir knows about it or not. The probate process establishes who owns it. It does not resolve what is attached to it. This is one of the most dangerous assumptions in rural estate planning. The will controls who gets the title. The courthouse controls what that title actually includes. The first problem, the mechanics lion. 7 years before the father died, he hired a contractor to build a new equipment shed on the property. The work was completed. There was a dispute over the final payment. The contractor filed a mechanics lien. It was a legal claim recorded at the courthouse that attached to the land as security for the unpaid debt. The father disputed the claim, made a partial payment, and considered the matter closed. The contractor disagreed. The lien was never released, and because the father assumed it had expired without a lawsuit being filed to enforce it, he never mentioned it to anyone. It hadn't expired. The lien was still within its enforceable period when the father died. The heir had to track down a contractor who had moved away 7 years earlier, negotiate a resolution with his estate, and get a release recorded. 4 months. A settlement payment the heir never saw coming. The second problem, the active boundary dispute. 3 years before the father died, a boundary dispute with the neighboring property owner had escalated to a lawsuit. The neighbor filed a quiet title action claiming a strip of land along the eastern fence line. The father's attorney filed a response. Both sides submitted survey evidence. Then the litigation slowed and the case sat in circuit court without resolution. The lis pendens remained recorded against the parcel the entire time. When the heir attempted to sell, the title search flagged it immediately. He was now the defendant in litigation he hadn't started. He had to retain the original attorney, review the full case history, and either resolve the dispute or disclose the active litigation to every prospective buyer, which reduced every offer he received. The dispute ultimately settled. The boundary was agreed. The lis pendens was released. But the process added 6 months to the estate settlement and legal fees that reduced what every heir received. The third problem, the undisclosed co-owner. 15 years before the father died, he had acquired the back 40 acres in a joint purchase with a business partner. Both names appeared on the deed as equal co-owners. Both held a 50% interest. The probate attorney identified the issue when reviewing the full parcel description. The father's estate could only distribute the father's 50%. The partner, still alive and still legally holding his 50%, had to be contacted and his interest dealt with separately. The partner wanted to sell. He was entitled to fair market value for his interest based on current appraisal, significantly higher than the original purchase price 15 years earlier. The heir had to arrange financing to complete the buyout. 3 months of negotiation on top of everything else. How to find these problems before the estate closes? Every one of these problems was discoverable before the estate closed. The courthouse had documented all 3. Search the mechanics lien index under the deceased owner's name and parcel description. Many counties maintain a separate lien docket from the main deed index. Check both. Search the Circuit Court Judgment Index for any active litigation involving the parcel or the deceased owner as a party. A lis pendens in the deed index points to a case, but the case file itself reveals the full scope of what is disputed. Search the full grantor index under the deceased owner's name, going back as far as the records allow. Every instrument they filed that references the parcel, not just the main chain deeds, a co-ownership deed, a deed of gift, a recorded easement. All of it comes with the land when you inherit it. A complete pre-inheritance search gives the estate time to begin resolving encumbrances before the heir accepts the title, while parties are still reachable, and before the clock starts running on a parcel with active disputes attached to it. What to do when the estate is already closed for open liens? Identify the lion holder, negotiate a resolution, obtain a written release, and record it at the courthouse. Confirm whether the lien's enforcement period has expired under your state's specific statute before assuming it is void. For active litigation, retain counsel familiar with the case history and determine whether settlement or continued litigation is the better path given the cost and timeline of each option. For undisclosed co-owners, contact the co-owner and negotiate either a buyout or a cooperative sale. If they are uncooperative and significant value is involved, a quiet title, action may be necessary to force a resolution. None of these are impossible. All of them are harder and more expensive when discovered after the estate has closed rather than before. Hidden power files is educational content. Laws vary by state. Always consult a licensed attorney for advice about your specific situation. If this is something every landowner should know, hit like so more people see it.